Now we start off with Theme 1, Intro to Labor Law and the Contract of Employment. So the two main sections of labor law is individual labor law and collective labor law. In the past, employment was regulated by the common law contract of employment, but it didn't give maximum protection. So in terms of individual labor law, the source is the law of contract, or Roman Dutch or common law consensus. And the purpose of individual labor law is to regulate the relationship between the employer and the employee. And the product of individual labor law is the employment contract. And now in terms of collective labor law, the source is the Labor Relations Act. So collective labor law is regulated by legislation. And the purpose of collective labor law is to regulate the relationship between trade unions and employees and employers and employers' organizations. And the product of bargaining is a collective contract or agreement. And you should know agreement, or the Labor Relations Act, takes precedence over individual provisions or agreements. So let's take a look at the hierarchy and sources of labor law. Well, first we have the Constitution, the Bill of Rights. Then we have the core rights of the Basic Conditions of Employment Act and the National Minimum Wage Act. In third place, we have collective agreements from bargaining councils. And then we have collective agreements outside of bargaining councils. In fifth place, we have sectorial or ministerial determinations. Number 6 is the Basic Conditions of Employment Act. Seventh is individual agreements, so the contract of employment. And lastly, at 8th place, we have the common law. So in terms of the BCEA, we have a default exclusion for people who earn above 254,000, and it used to be 241.1 thousand. So when dealing with labor issues, the first step is to consider the employment contract. Then you consider the Basic Conditions of Employment Act. In the third step, you compare the Basic Conditions of Employment and the employment contract, and you take the most favorable terms, so they take precedence. In the fourth step, you'll consider ministerial or sectorial determinations. But remember, these determinations can't contravene the core rights of the Basic Conditions of Employment Act. And then the last step, step 5, would be to consider collective agreements. And a collective agreement in a bargaining council can't limit leave to 2 weeks. In practice, it just won't happen. But now let's talk about the nature of the employment contract. Well, it's a reciprocal contract, so there's rights and obligations for both parties. The employee places services at the disposal of the employer. The employee has a right to receive remuneration for services rendered under the authority and supervision of the employer. And whether it's verbal or written, it's a valid contract. But now let's talk a bit about independent contractors. Well, here there's a reciprocal contract for a piece of work for the client. They're not part of the employer's enterprise and aren't under the control of the employer. So the control test would fail here. The dominant impression test would be mandated though. These independent contractors are not subject to the authority of the employer. For example, professional services like a doctor, attorney, mandator to mandator. But why do we distinguish? Well, only employees have legislative protection, so they have access to protection of labor legislation like the Labor Relations Act, the BCEA, and the Employment Equity Act. They have access to the CCMA, the Labor Council, and the Labor Appeals Court. They have the freedom to join trade unions. And lastly, they're entitled to social security benefits like COIDA, UIF, etc. But now let's talk about the statutory presumption. Well, a worker is presumed to be an employee if one or more of the following 7 factors are present, and this is until the employer proves the contrary. So first, the manner in which a person works is subject to the control or direction of another person. Second, a person's hours of work are subject to the control or direction of another person. Third, the person forms part of the organization. Fourth, the person is given tools of the trade. Fifth, they've worked for an average minimum of 40 hours per week over the last 3 months. Sixth, the person is economically dependent on the other person. And seventh, the person works for one person only, provided they earn below the threshold. Now let's take a look at the common law test for if a person is an employee or not. So first is the control test. This looks at the control over the work the person does. There should be some degree of control. Complete control isn't essential. And control is more extensive in the employment contract. For independent contractors, there's some degree of control, but largely absent. That said, the control test is inadequate to distinguish between the above-mentioned contracts. We also had the organization test, and that looks at if the person is part and parcel of the organization. But that test forms part of the dominant impression test. So in terms of the dominant impression test, it makes sure that the services should be done personally, so no delegation. There should be fixed hours or regular payment. The disciplinary code should be subject to the employers. There should be benefits like a pension fund, medical aid scheme, etc. and control is required to a degree. So in terms of these steps to determine if a person is an employee, first you take a look at the definition of an employee. Then you use the dominant impression test. Then you look at the code of good practice in the LRA. You take a look at substance over form. And lastly, we make use of the rebuttable presumption, but this is only applicable to employees earning equal to or less than $254,371. If they earn more than this, then the onus is on the employee. But now let's talk about the conclusion of an employment contract, the essentialia and conditions. Well, it has the same requirements as a normal contract. So there has to be consensus, contractual capacity, possibility, legality, and formalities. And if there's an offer and acceptance, then it's a binding contract. That means there's consensus, so there should be agreement. And there can be no formalities and can be concluded verbally. But the employee can request the employment contract in writing. And you should know that an employer can terminate the employee's employment before the employee even starts under certain circumstances. And customs and practice can give rise to tacit terms, and the court will accept such terms if the terms are an inevitable consequence of the agreement between the parties. The terms aren't in conflict with other terms in the contract or law. And again, the court will accept the terms if there's acceptable evidence for the existence of the custom. So this is if both parties were aware of the custom or if it was a common practice in the industry or area. And in this case, they must provide a letter of appointment alone or the letter of appointment with the employment contract later. But now let's talk about employer's delictual or vicarious liability. So the employer is liable for the unlawful and delictual acts of an employee performed during the course of business. But the employer still has recourse against the employee depending on the circumstances. The employer can discipline the employee for misconduct and even claim repayment. But what are the requirements for vicarious liability? Well, there must be an employer and employee relationship, so there needs to be a contract of employment. And the delict must have been committed by the employee in the course and scope of their duties. But now let's talk about restraint of trade, ROT. Well, this is when an employee is prevented from starting a business in competition with their employer, or prevented from working for the employer's competition for a specified period in a specific geographic area after leaving the employment of their employer. So there's tension between protecting the employer's commercial interests and the ex-employee's right to use their own skill to generate income. But now let's take a look at some of the factors determining the reasonableness of a restraint of trade. While we take a look at the areas and period of restraint, then we take a look at whether the ROT has been concluded to prevent healthy competition or whether it is concluded to genuinely protect the employer's interests. We also take a look at the nature of the business and whether the employee has been prevented by restraint from utilizing their own skills, expertise, and experience. Now we move on to Theme 2, a floor of protection and the Basic Conditions of Employment Act and the National Minimum Wage Act. So basic conditions of employment are the provisions of the BCEA or sectorial determinations that stipulate a minimum term or condition of employment and includes the national minimum wage. And the Basic Conditions of Employment Act, the BCEA, ensures vulnerable workers aren't exploited by setting a floor of rights. So it regulates the minimum conditions of employment. But what is a domestic worker? Well, this is an employee who performs domestic work in the home of their employer and includes a gardener, driver, caretaker, etc., but doesn't include a farm worker. But then what is an employee? Well, an employee is any person excluding an independent contractor who works for another person or the state and who receives or is entitled to receive remuneration, and any other person who in any manner assists in the carrying on or conducting the business of an employer. Let's take a look at the objectives or aims of labor legislation. Well, it gives effect to Section 23 of the Constitution, it gives effect to the standards set by the International Labour Organization, and it advances social justice and economic development. Working conditions for vulnerable and unorganized labor meet socially acceptable standards. But what are the exclusions of the Basic Conditions of Employment? Well, employees who earn more than the BCEA threshold of $254,000 aren't covered by limitations regarding working hours and overtime. and overtime pay. The BCEA applies to people undergoing vocational training except where employment is regulated by another law. Senior managerial employees, sales staff who travel to customers and who regulate their own hours of work are also excluded. Employees who work less than 24 hours a month for an employer are also excluded. Employees engaged in unexpected work which must be done without delay and which can't be performed during ordinary working hours are also excluded. Employers who employ fewer than 5 employees don't have the duty to keep records or particulars of employment, etc. And obviously, employees whose employment is subject to a bargaining council collective agreement or to a sectorial determination or individual agreement are also excluded. Now we move on to theme 3, Equality at Work and the Employment Equity Act. So some of the hotspots for disputes and litigation is transformation versus efficiency, equality versus efficiency, and reverse discrimination. So we need to consider whether affirmative action is a shield or a sword. So let's take a look at the Employment Equity Act. While its purpose is protection against unfair discrimination and implementation of affirmative action, so prohibition of unfair discrimination. But what are some of the objectives of the Employment Equity Act? Well, it aims to promote equal opportunities, fair treatment, and eliminates unfair discrimination. It redresses the disadvantages of designated groups and implements an affirmative action plan. It ensures equitable representation and implements anti-discrimination measures. It also promotes constitutional rights and boosts economic development and efficiency. In terms of equity in employment, companies will also have to report to the DOL, the Department of Labor, about implementation and progress. Let's talk a bit about constitutional equality. Well, everyone's equal before the law and has a right to equal protection and benefit. Everyone gains full and equal enjoyment of rights and freedoms. There are legislative measures to promote equality as well as to promote and advance persons. And categories of persons disadvantaged may be implemented. The state may not unfairly discriminate directly or indirectly on 16 listed grounds. And no person may unfairly discriminate. And discrimination on a listed ground is unfair unless it's established that it's fair. Let's talk a bit about equality and affirmative action. Well, it's there to address past unfair discrimination. And it's in place to create equal opportunities for all people. And it's justified because it creates inclusivity and overcomes institutionalized discrimination. And employers must consider national and regional demographics when considering appointments. And there's no need to appoint or promote a group of people in an adequately or overrepresented workplace. But now let's talk about discrimination and infringement of dignity. Well, discrimination means the different treatment of people, but it's not always wrong. But unfair discrimination on a listed or arbitrary ground without justification is the problem. So direct discrimination is when a person is treated differently, they belong to a specific category, and they're treated differently and disadvantaged on a specific ground. Now, indirect discrimination is where at first sight there's neutral criteria, but there's differentiation based on so-called objective criteria. But regardless, it entails the disadvantage of a particular category of persons. Let's talk a bit about proof of discrimination. Well, if discrimination is alleged on any one of the listed grounds, and there's 16 of them, the rebuttable presumption is that it's unfair and the onus is on the employer to prove it didn't happen or that it's justifiable. On a balance of probabilities, if it's an unlisted ground, the onus is on the person who alleged discrimination to prove discrimination and unfairness. Now let's talk about the application of the Employment Equity Act. While it applies to all employers and employees, affirmative action, however, only applies to designated employers and designated groups of employees, and exclusions would be members of the SANDF, etc. And affirmative action binds the state. But what are the designated employers it applies to? Well, these are employers who employ more than 50 employees, or less than 50 but equal to or more than the annual turnover for that small business. This is also the municipality and organs of state, or the employer designated with regard to a collective agreement or voluntary application to be the designated employer. But then who are the designated groups? Well, here we're talking about Black people, women, and people with disabilities. Chinese people are also included. And we're talking about citizens of South Africa by birth or descent, or became citizens by naturalization. But let's talk a bit about the meaning of discrimination. Well, this is the different treatment of different people. Unfair discrimination is prohibited by law, and this is when the criteria is unrelated to employment or the inherent job requirements and has the effect of disadvantaging persons or groups. That said, discrimination justly and fairly applied is lawful. But what is the employer's defense against alleged discrimination? Well, they can say it's due to inherent job requirements, so it's a fair criteria relevant to business objectives or effective to achieve them. Or they can say it's due to affirmative action, so it's not unfair discrimination. So Chapter 2 prohibits indirect or direct discrimination in policy or practice on the grounds of HIV status, political opinion, age, belief, pregnancy, or any other arbitrary ground. Harassment is prohibited, and medical tests are prohibited unless permitted by legislation. So it should be justified with regard to medical facts, employment conditions, social policy, inherent job requirements, or fair distribution of benefits. And you can only test for HIV and AIDS with a labor court order. So you should know a difference in the terms and conditions of employment between the employees of the same employer performing the same or substantially the same work or work of equal value, directly or indirectly based on any one or more of the listed or arbitrary grounds, constitutes unfair discrimination. Let's talk a bit about dispute resolution. So remember, you shouldn't confuse the Employment Equity Act dispute resolution with dismissal based on unfair discrimination. So EEA dispute resolution is not the same as dismissal based on unfair discrimination. So for a dismissal, you claim compensation, and for unfair discrimination, you claim damages. The referral must be within 6 months from the incident, taken to the CCMA and not the bargaining council. The process is conciliation at the CCMA, and then it's taken to the labor court if needed for adjudication. The exceptions to this would be arbitration by agreement, sexual harassment, earning less than the threshold, and then you go to arbitration at the CCMA. So if the dispute or discrimination is based on a listed ground, then the employer must prove that there was no discrimination or that it was justified, rational, and not unfair. If the discrimination is based on an arbitrary ground, then the employee must prove it's unfair, irrational, and unjustified. So again, what is affirmative action? Well, these are measures to ensure that suitably qualified persons from designated groups have equal job opportunities and representation. So suitably qualified means they have formal qualifications, prior learning, relevant experience, or they have the capacity to acquire the skill or knowledge within a reasonable time. And affirmative action includes measures to identify and eliminate barriers, further diversity, make reasonable accommodation, and retain and develop affirmative action candidates. But what are the duties of designated employers? Well, they have to consult with employees, they have to conduct staff analysis with regard to practices and policies, they have to prepare and implement an employment equity plan, and they need to report the progress to the Director General annually, so the first working day of October. Now we move on to Theme 4 with the scope and application of the Labour Relations Act. Let's talk a bit about the development of South African labour. So NEDLAC, the National Economic Development and Labour Council, encourages social dialogue to develop labour. So the development of effective policies relating to economic and labour matters. But what are the aims of NEDLAC? Well, it's to promote economic growth and participate in decision-making for equity, to reach consensus and conclude agreements relating to economic and social policy, consider policy changes or amendments or proposed legislation before going to Parliament for approval, and to encourage and promote coordinated policy on social and economic matters. So the main objectives of the Labour Relations Act is to advance economic development, social justice, labour peace, and democratization of the workplace. So dispute resolution structures include the CCMA, the Labour Court, and the Labour Appeals Court. Then we have bargaining councils and statutory councils. The Labour Relations Act also complies with the Constitution and International Labour Organization conventions. But now let's talk about the exclusions of the Labour Relations Act. Well, members of the SANDF and the State Security Agency are excluded. And obviously it only applies to employees earning less than the threshold. And remember, the definition of an employee is any person excluding an independent contractor who works for another person and is entitled to receive remuneration and assists in the carrying on or conducting of the business of the employer. The people also included in the application of the Labour Relations Act is casuals and part-time workers, managers, directors, and shop stewards employed by the employer, migrant workers, and probationary workers. These people are all protected by the LRA and are entitled to dispute resolution at the CCMA, bargaining council, or labor court. And dismissed employees have access to the dispute resolution proceedings. But now, what is the definition of temporary service or employment? Well, this is employment of less than 3 months, and maybe the substituting of an ordinary employee, so replacing the absent employee with a temporary one. So doing work for a period as a temporary service is determined by a bargaining council collective agreement, sectorial or ministerial determination. But now let's take a look at standard versus atypical employment. So standard employment is stable employment, full-time for an indefinite period and protected by labor legislation. So the Basic Conditions of Employment Act, the Labor Relations Act, and the Employment Equity Act. And they also have income security and benefits, so medical, housing subsidies, maternity allowances, etc. But then atypical employment is precarious, limited duration, casuals and employees of labor brokers, TES. So let's talk a bit about temporary employment services, labor brokers. So if the employee is performing a temporary service, they're an employee of the TES or the labor broker. If the employee isn't performing a temporary service, they will be deemed to be the worker of the client, so where the TES placed them. And in such a case, they'd be entitled to equal terms and conditions of service like the other employees of the client. The TES worker or leased employee can claim against the client or the TES, the labor broker, in respect of unfair dismissal and other contraventions. The TES or labor broker must provide the employee with written particulars of employment. It also mustn't employ the employee on terms and conditions contrary to any employment law applicable to the client. So if the employee isn't performing temporary services, so the 3 conditions as defined, so essentially they're working longer than 3 months, etc., they're deemed to be or they become an indefinite worker of the client, and they're entitled to the same terms and conditions of work as the other workers. The above doesn't apply to employers with fewer than 10 employees or employers with fewer than 50 employees that has been in operation for less than 2 years. Or it doesn't apply if the employee is engaged in terms of a fixed term contract, FTC, permitted by legislation, collective agreement, or sectorial determination. So what are fixed term contracts? Well, a fixed term contract may be longer than 3 months if the nature of work is of a limited or definite duration, or there's a justifiable reason, for example, replacing an absent employee, temporary maternity leave stand-in, etc. Or there's a temporary increase in workload, seasonal work, student gaining experience, etc. Let's talk about the definition of a part-time employee. Well, they're remunerated wholly or partly as per time worked and works less hours than a comparable full-time employee per month. If the employee earns below the threshold, they should be treated on the whole the same as a full-time employee. The employee is entitled to training and can apply for jobs. But then the above doesn't apply to employers with fewer than 10 employees or an employer with fewer than 50 employees that's been in operation for less than 2 years. Or there's a fixed term contract permitted by legislation, collective agreement, or sectorial determination, or they work less than 24 hours for 3 months. Now let's talk about trade unions and employers' organizations. Well, here we have collective bargaining and collective agreements, and you register trade unions and employers' organizations at the DOL, the Department of Labor, and then they issue a registration certificate. If the application is rejected, then one can request written reasons from the DOL, and you can appeal to the labor court in 60 days. Now let's talk about bargaining councils. Well, these are also registered at the DOL. And here, parties for the sector and the Constitution is also considered. And the parties to bargaining councils are only registered trade unions and employers' organizations. And they take 90 days to consider an application. You have 30 days to provide information if requested. And you can also approach the labor court. And applications are advertised in the Government Gazette and submitted to NEDLAC. Now let's talk about statutory councils. Well, these are established in a sector or area where no bargaining council exists. A registered trade union or employers organization, or 2 or more registered trade unions or employers organizations acting together, whose members employ at least 30% of the employees in a sector or area may apply for a statutory council. Let's talk a bit about the Commission for Conciliation, Mediation, and Arbitration, the CCMA. Well, they resolve any dispute referred to it through conciliation, and if that's unsuccessful, then through arbitration. Now let's take a look at the Labor Court. Well, it has concurrent jurisdiction and powers with the High Court. The Basic Conditions of Employment Act has exclusive jurisdiction. So in terms of a breach of employment contract, you've got the common law breach, which is aligned with the High Court, and the basic conditions of employment, which is aligned with the Labor Court. Now let's take a look at the Labor Appeals Court. Well, they have exclusive jurisdiction to hear and determine all appeals against judgments and orders of the Labor Court and to decide on questions of law referred to it by the Labor Court. The Labor Appeals Court may remit the case back to the Labor Court for a further hearing. The court may confirm, set aside, or amend the judgment or order made by the Labor Court. The decision of the Labor Appeals Court is final, and there's no right of appeal against its final judgment or decision. Now let's talk a bit about workplace forums. Well, these are innovative creations of the Labor Relations Act to ensure worker participation in the workplace, and they're in place to avoid adversarial industrial relations by way of consultation and joint decision making. It can be established in a workplace with 100 or more employees. The workplace forum is not a negotiating or bargaining unit. It's rather a platform where the employer consults with all employees on broader workplace issues. For example, policy issues, workplace restructuring, job grading, retrenchment policy, plant closures, mergers, education and training, etc. In a few limited instances, the Labor Relations Act requires that the employer and the workplace forum take joint decisions, such as disciplinary codes and procedures and affirmative action policies. Now we move on to Theme 5 with dismissal. So Section 185 of the Labor Relations Act says that every employee has a right not to be unfairly dismissed. So the two requirements for a fair dismissal is that it has to be substantive, for a good reason, and it has to be procedurally fair. And only one leg needs to be proven for an unfair dismissal. So the three valid reasons for a dismissal is misconduct, poor work performance or incapacity, and the operational requirements of the employer, so retrenchment. But what is dismissal? Well, this is the termination of employment with or without notice. So for a fixed-term contract, the employee had a reasonable expectation the contract would be renewed on the same terms, or it's been renewed on less favorable terms. Or they retain the worker's services on an indefinite basis, but the employer refuses to allow the employee to resume work. Dismissal could also be where the employer refused to employ the employee after maternity. It could also be where the employer dismisses employees for the same reason, but selectively re-employs a few. It could also be constructive dismissal, where the employer made continuous work intolerable. Dismissal could also be where the employer terminated the employment contract after the business is transferred as a going concern. Let's talk a bit about resignation versus dismissal. So the employee is free to tender resignation at any time subject to the notice period. The termination of employment by resignation is not the same as dismissal. Where the employee offered to resign and the employer has accepted the resignation, the employee can't withdraw resignation without the consent of the employer. In terms of a hot-heated resignation, courts have said that the employer should be slow to accept a resignation made in the heat of the moment. Now let's talk about constructive dismissal. Well, these are actions of the employer which drive the employee to leave, whether there's resignation or not. Resignation isn't a bar to relief as the employee has been constructively dismissed. It could also be where the employee's employer confronts them with the choice to either resign or they summarily dismiss them. Constructive dismissal could also be where the employee is being forced by the company to accept a voluntary retrenchment. The following should be considered for constructive dismissal. Did the employee intend to bring an end to the employment relationship? Was the employment relationship intolerable? Was the unbearable situation likely to endure for a period that justified termination of employment? And lastly, was resignation the only reasonable option available to the employee in the circumstances? Let's take a look at some of the critical issues in constructive dismissal. While the employee is expected to try and resolve their grievances prior to resigning, the employee can't claim to have been constructively dismissed if they resign to avoid disciplinary hearings, and the employee should give the employer reasonable time to rectify the situation, and mustn't be too impatient to await the outcome of the employer's attempts to find a solution to the perceived intolerable situation. So again, constructive dismissal is termination by the employee, with or without notice, that made continued employment intolerable. So the objective test is that the employee would have continued if not for the intolerable or unbearable circumstances. So no reasonable person can expect the employee to continue employment. And the onus is on the employee to prove employment was intolerable. So the two-stage test. And the employer has to counter that dismissal was indeed fair and not unreasonable. Now let's talk about automatically unfair dismissals. This is usually when the employer dismissed the employee as an act of discrimination, or the employee exercised their rights with regard to the Labor Relations Act. So this could be dismissal because the employee exercised their right to freedom of association, They disclosed information they're lawfully required or entitled to give another person. They exercised their rights with regard to the Labor Relations Act. They participated in proceedings in terms of the Labor Relations Act. Dismissal because they participated in a strike. They refused to perform the duties of other employees while they are striking or during a lockout. They refused to accept the employer's demand, so dismissal lockout. It could also be a pregnancy-related dismissal, dismissal due to the employer's unfair discrimination, dismissal due to the transfer of the business, and dismissal because an employee made a protected disclosure. And in terms of the date of dismissal, this is the earlier date between the date on which the contract of employment was terminated and the date on which the employee stopped rendering services to the employer. Now let's take a look at the requirements for a fair dismissal. Well, the employer must prove dismissal was substantive and procedurally fair. So substantive fairness relates to the reason. There are 3 reasons for dismissal: misconduct, incapacity or poor work performance, and operational requirements. And then procedural fairness relates to the procedure, so the disciplinary inquiry. So the onus is on the employer to prove on a balance of probabilities that dismissal was fair. Before dismissal, the employer should always consider alternatives to dismissal, so disciplinary codes if any and progressive discipline. Now let's take a look at the first reason for dismissal: misconduct. This is dismissal of an employee for contravening the rules set by the employer. Dismissal is the last resort. Depending on the seriousness of the offense, the employer is advised to use progressive discipline. Now let's take a look at substantive fairness for misconduct. While the employee must have contravened a rule, the rule that the employee contravened should be reasonable and valid. The employee should be aware or was reasonably expected to know. The rule should be consistently applied, and the dismissal was an appropriate sanction. If this isn't adhered to, then it's an unfair dismissal. Now let's take a look at the procedural fairness for misconduct. While the employer must hold a disciplinary hearing, the employee must be allowed to present their side of the story, the employee must be provided with the charges before the hearing, and the employee must be provided with the outcome of the hearing. But now let's talk a bit about the 2 fundamental principles of natural justice. Well, we have the audi alterum partem principle. So the requirement here is that anybody adversely affected by a decision should have an opportunity to state their case before a decision is made. So procedural fairness. So what are the minimum requirements for natural justice? Well, you must notify the person of the allegations using language they can understand. You must give notice of disciplinary action and charges. You must allow the person the opportunity to state their case in response to the allegations, and allow them a reasonable time to prepare the response and legal representation where permissible. Now let's take a look at the second reason for dismissal: incapacity. Well, this is the dismissal of an employee for not having the ability to do the job for which they're employed. So there's 2 types of incapacity: ill health and poor performance, so lack of knowledge, skill, or ability. Now let's talk about substantive fairness for incapacity. Well, this is when the employee failed to meet a performance standard. So poor performance, the existence of a reasonable standard, and proof that the employee's performance actually fell below that standard. Now let's take a look at the procedural fairness for incapacity. While they have to inform the employee of the poor performance, the employer must have taken reasonable steps to assist the employee. So counseling, training, guidance, instruction, etc. Perhaps give them medical treatment or placement in another position. And they must give them a proper hearing before dismissal. Now let's talk about incapacity with regard to ill health. Well, here the employee is unable to do their job due to an illness or injury that affects their physical or mental health. So the substantive fairness for incapacity with regard to ill health is that there needs to be proof that the employee is incapable of performing their duties due to the illness or injury. But now let's talk about procedural fairness for incapacity in terms of ill health. Well, the employer must investigate the cause and extent of the employee's incapacity. So the seriousness of the incapacity, so permanent or temporary, the nature of incapacity, ascertaining whether the employee is capable of doing the job, potential alternative or adapted employment, and the employee must be given an opportunity to make representations prior to being dismissed. Now let's take a look at dismissal due to operational requirements, so retrenchments. So this is dismissal based on technological advancement, so technology makes the job obsolete. Or economic reasons, so downsizing due to a drop in demand. And lastly, structural needs, so positions becoming redundant because of the restructuring of the business. This could be closure, relocation, or sale and transfer of the business. So the substantive fairness for operational requirements would be technological, economic reasons, or structural needs. But now let's talk about the procedural fairness for operational requirements. Well, first you need to issue a notice requesting a consultation with the relevant parties. So this could be trade unions, employees, workplace forums, etc. This notice must include the reasons for retrenchment, the alternatives considered and reasons for ejecting, the number of employees likely to be retrenched, the number of employees employed by the employer, the method used for selection, so the criteria, when the dismissal will take place, the proposed severance package and any further assistance, future re-employment, etc. And the employers and consulting parties must engage in a meaningful joint consensus-seeking process, minimizing the impact of retrenchments. But now let's talk about retrenchments in the context of business rescue. Well, the business rescue practitioner must draft a proposal of a business rescue plan after consultation with the affected persons, so employees, trade unions, shareholders, creditors, etc. The business rescue plan then needs to be considered and voted for by the affected parties together with the creditors and management of the company. It requires the practitioner to ensure that all the information in the business rescue plan can facilitate or assist the affected persons in deciding whether to accept or reject the plan. And the plan must also comply with the Labor Relations Act if retrenchments are contemplated. Now we move on to the transfer of a business as a going concern. So there are protections available to an employee as a result of the sale of a business. So the first thing is that the new employer steps into the shoes of the old employer in respect of all existing employment contracts. The second thing is that all rights and obligations that existed between the old employer and employee continue to exist between the new employer and the employee. And finally, the transfer doesn't interrupt the employee's continuity of employment. Terms that existed before may be changed but mustn't be less favorable. Anything done before the transfer by or in relation to the old employer, including the dismissal of an employee or the commission of an unfair labor practice or an act of discrimination, will be considered to have been done by or in relation to the new employer. So for a transaction to fall within the scope of the transfer of a business as a going concern, the following three elements must be simultaneously present. The transfer of an entity by one employer to another, the transferred entity must be the whole or part of a business, the business must be transferred as a going concern. The sale of share transactions don't attract the attention of Section 197, as the identity of the employer remains unchanged and hence contracts of employment remain unchanged. And business includes the whole or part of any business, trade, undertaking, or service, so it doesn't have to be the whole thing. In terms of the rights of employees, a dismissal for a reason related to the transfer of a business as a going concern will constitute an automatically unfair dismissal in terms of the Labor Relations Act. Now let's talk about dispute resolution, so unfair dismissal. So in terms of misconduct and incapacity, it must be reported in 30 days. It should be referred to the CCMA or bargaining council for conciliation, thereafter arbitration. Or it could be taken to the labor court within 90 days from the date of certificate of non-resolution, so after trying conciliation. In terms of operational requirements, it should be reported in 30 days. It's referred to the labor court for adjudication. And if only one employee is retrenched or the employer employs less than 10 people, then the CCMA has jurisdiction. In terms of automatically unfair dismissals, it's referred to the labor court for adjudication within 30 days. In terms of unfair labor practices, this should be reported in 90 days. It's referred to the CCMA or the bargaining council. Occupational detriment must be referred to the labor court for adjudication. Unfair discrimination should be reported within 6 months. It's referred to the CCMA for conciliation, thereafter the labor court for adjudication. Let's take a look at the remedies for unfair dismissal. So first we have reinstatement. This is the first prize, and this is returning the employee to their previous position. And then we have reemployment, so hiring someone who was previously employed but left. And then we have compensation, and this usually happens when dismissal was substantively fair but procedurally unfair. If the employee prefers compensation over reinstatement or reemployment, if a future relationship is intolerable, and we could use compensation when we have automatically unfair dismissals or operational reasons. So compensation should be fair and reasonable to both parties at the discretion of the court or arbitrator. They can also interdict the employer to pay compensation, and maximum is 24 months pay. Now we move on to theme 6 with unfair labor practices. So this deals with unfair conduct by the employer relating to promotion, demotion, probation, training, provision of benefits, unfair suspension and other disciplinary action that aren't dismissals, failure to re-employ or reinstate in terms of agreement, and lastly, occupational detriment, for example, being sidelined for whistleblowing. So what is promotion? Well, promotion is being raised to a higher status, greater authority, being raised to a higher rank or office. Unfair actions by the employer could be failure to adhere to objective standards, such as arbitrary or inconsistent conduct. There's a managerial prerogative to promote, but the employer must act fairly. So in terms of procedural fairness, all candidates must be given a reasonable opportunity for promotion. So the employer must adhere to its own procedure. The employee may challenge the composition or competency of the selection panel. And acting in a senior position doesn't give you an automatic right to be promoted. And the promotion should involve some reward. A higher status without a higher salary could be regarded as a form of non-promotion or demotion. So you should consider the development of the employee. And then in terms of substantive fairness, these are the reasons why the employer decides to choose one employee over the other. So there should be a link between the reasons and the decision, and the discretion should be the most suitable person. Subjective considerations could be performance at an interview. The employer must be able to justify their decision or provide reasons. The arbitrator limits interference to instances where the employer hasn't applied themselves. Well, what about demotion? Well, this is when an employee is moved to a lower rank or level. And this is only allowed if the disciplinary code provides for demotion. The employer must consult first where demotion isn't due to disciplinary sanction. If the employer fails to train the employee, that's an unfair labor practice, especially if it's a contractual obligation. The Employment Equity Act, through affirmative action, places the duty on the employer in the absence of a contractual duty. But now let's talk a bit about unfair suspension and other disciplinary action. So these are unfair actions when suspending or imposing a disciplinary sanction short of dismissal. This could also be precautionary suspension with pay to allow for investigation or protection of business interest. But a valid reason is required for suspension and consideration of any prejudice to the employee. Vague reasons may be considered unlawful. The right to be heard is limited, but ideally the employer should give the employee a proper opportunity to make representations. But now let's talk about probation. So this is usually for a newly hired employee to evaluate their performance. So first, it must be reasonable. Normal dismissal procedures apply. And unfair treatment relating to probation will be an unfair labor practice, but it excludes alleged unfair dismissal. And you should know that the Protected Disclosures Act 26 is to eradicate criminal and other irregular conduct by the employer or fellow employees. So what are the objectives of the Protected Disclosures Act? Well, it's to protect the public or private employee from being subjected to occupational detriment for making a protected disclosure, to provide remedies, and to provide procedures to disclose information regarding employer and properties. But what types of information are we talking about? Well, this could be a criminal offense committed or being committed, failure to comply with legal obligations, the miscarriage of justice, where the health or safety of the individual is endangered, where there's damage or possible damage to the environment, unfair discrimination, and the likely or deliberate concealment of all of the above. But then when will the disclosure be protected? Well, this is when it's made to a legal practice or legal advisor with the object of obtaining legal advice or in the process of obtaining such. It'll also be protected if it's made in good faith to the employer, made in good faith to the public protector or auditor general, or when it's made in good faith to a member of cabinet or executive council of province. The disclosure must not be made for personal gain. It must be reasonable to make the disclosure, and there should be reason to believe that there will be occupational detriment if the disclosure is made to the employer. But now, what is occupational detriment? Well, this is being subjected to any disciplinary action, being dismissed, suspended, demoted, harassed, or intimidated, being transferred against your will, if there's been a unilateral change to terms and conditions of employment which is prejudicial, being refused a reference or being provided with an adverse or negative reference, being denied appointment, and being otherwise adversely affected in respect of their employment. So as we know, unfair labor practices must be referred to the CCMA or bargaining council within 90 days for conciliation, thereafter arbitration. The exception is that disputes regarding occupational detriment must be referred to the labor court for adjudication. The remedies could be reinstatement in the case of demotion, reemployment in the case of demotion or dismissal, or compensation. And this would be a max of 12 months pay, and it must be just and equitable. Now we move on to theme 7 with collective bargaining. Well, first you should know that there's no legally enforceable duty to bargain, and there's no duty on employers to negotiate. It's merely encouraged. That said, should employers refuse to bargain, employees may possibly strike. And some of the possible tools to encourage collective bargaining include organizational rights, strikes, workplace forums, agency shop, and closed shop agreements. But now let's take a look at representativity. While majority membership is when the trade union has a clear majority of members in the workplace, therefore 50% plus one employee have joined the union. And then a sufficiently representative trade union is a registered trade union with sufficient or about 30% of the employees in it. These may also demand organizational rights. And then we have minority representative trade unions. These in principle have no organizational rights. Less than 30% of the employees in the workplace have joined it. So but what are these 6 organizational rights? Well, the first is right of access to the workplace, and this is to communicate with and or recruit members. Second, we have the deduction of union subscription fees from members' wages. Third is paid leave during working hours for office bearers. Fourth is the appointment of trade union representatives or shop stewards at the workplace. Fifth is the right to disclosure of information from employees or the employer. And lastly, they have paid leave for union representatives. But you should remember that not all trade unions are entitled to all the organizational rights. Majority trade unions are entitled to all 6 rights. Sufficiently representative trade unions are entitled to just 3 rights: access to the workplace, deduction of union fees, and leave for office bearers. And you should know that members of a bargaining council automatically receive the right to access to the workplace and the deduction of union fees regardless of representativity. But now let's talk about exercising organizational rights. The procedure to be followed if a trade union wants to exercise one or more organizational rights is that they must first notify the employer in writing. The notice must attach the registration certificate of the trade union. And the notice must include the following. It should state the workplace where rights are to be exercised. It should state the representatives of the trade union in the workplace. It should state the facts relied upon to prove that it's a sufficient or majority union. It should state the rights the union seeks to exercise. And lastly, it should state the manner in which the union seeks to exercise those rights. Within 30 days after receiving the notice, the employer must meet with the trade union to negotiate. The trade union and the employer conclude a collective agreement, or they refer the matter to the CCMA for conciliation or arbitration. But now let's talk about disputes regarding organizational rights. Well, if there's no collective agreement, the dispute must be referred to the CCMA and not the bargaining council. The matter can be brought by any party, and they start with conciliation, and if there's no resolution, then it's arbitration. In deciding whether to grant organizational rights, the commissioner must guard against the proliferation of unions in the workplace, and rather encourage a system of a single union. They should also consider the nature of the workplace, organizational rights the union wants to exercise, the nature of the sector the workplace is in, organization's history, etc. So you should know that every collective agreement binds the parties to the agreement, each party to the agreement and the members of every other party, the members of a registered trade union, and the employers who are members of a registered employers organization. Employees who are not members of the registered trade union that's party to the agreement may be binded, provided that this trade union is the majority union and the agreement expressly binds non-members. But now, what are agency shop agreements? Well, this is an agreement between the employer and the majority union which requires an agency fee to be deducted from non-union employees. The employees who aren't members of that union must be identified in the agreement and must be eligible for union membership. And the agency shop agreement is only binding if non-members aren't compelled to become members of the trade union. But now, what are closed shop agreements? Well, this is an agreement between the employer and the majority union that requires all employees covered by the agreement to become members of the trade union. But now, what about funding agreements? Well, this is a collective agreement concluded in a bargaining council to fund operational and admin activities of the council, dispute resolution funds, training and education schemes, pension, medical aid, etc., and they're valid for 12 months. Now we move on to theme 8 with strikes and lockouts. So strikes are usually by employees and lockouts are usually by the employer. And these are tools to encourage collective bargaining. But now let's take a look at industrial action. So employees have a right to strike, and this is guaranteed by the Constitution. But what is a strike? Well, this is the partial or complete concreted refusal to work, or the retardation or obstruction of work by persons who are or have been employed by the same or different employers. And this is to remedy a grievance or resolve a dispute in respect of any matter of mutual interest between the employer and the employee. But now let's take a look at the different forms of strike action. Well, first we have economic strikes. So this is the withdrawal of labor to improve conditions of employment. Then we have secondary or sympathy strikes. Here, employees strike not because of their own employment conditions, but in support of other employees, the primary strike. And then we have a go slow. This is the reduction in the pace of work, or the retardation of production. And then we have work to rule strikes. This is working strictly to the rules, according to the prescribed rules, with the result that the pace of work reduces. And then we have sit-in strikes. Here, employees occupy the workplace to obstruct and impede admission to the workplace, so essentially block people. But now let's take a look at the prohibited strikes. So no person may take part in industrial action if a collective agreement relating to the issue at hand prohibits it, if an applicable agreement requires the issue in dispute to be referred to arbitration, if the issue in dispute is one that a party has the right to refer to arbitration or the labor court in terms of the Labor Relations Act, if it's an essential or maintenance service, if it's during the first year of a sectorial determination in terms of the Basic Conditions of Employment Act, and if the determination regulates the issue in dispute, and the strike is also prohibited when the issue is regulated by an arbitration award, collective agreement, or a ministerial determination. But now, what are essential services? Well, this is a service which, if interrupted, can endanger life, personal safety, or health of the whole or any part of the population. This could also be the parliamentary service and the South African police services. So you should know that essential service workers may not strike. The Essential Services Committee, the ESC, under the CCMA can determine whether a service, full or part thereof, is essential or not. But then what are maintenance services? Well, this is if the interruption of that service has the effect of material physical destruction to any working area, plant, or machinery. If there's no collective agreement regulating the maintenance service, an employer may apply to the ESC to declare whether the whole or part of the operations are a maintenance service or not. Now let's take a look at the procedural requirements for a protected strike. Well, first, the issue must be referred to the Bargaining Council or the CCMA for conciliation. A certificate of non-resolution must be issued, or 30 days has lapsed since the referral was received by the Bargaining Council or the CCMA. And lastly, 48 hours of written notice must be served on the employer before commencing with the strike. And if you choose arbitration, you can't strike anymore. But now, what are the consequences of a protected strike? Well, an employee isn't committing a delict or breach of contract for taking part in a protected strike. That said, an employer isn't obligated to pay an employee for the services that they didn't render during the strike. An employee can't be dismissed for taking part in a protected strike. An employer can still dismiss an employee for misconduct while participating in the protected strike or for operational requirements. But now let's take a look at the consequences of an unprotected strike. Well, an employer may apply for an interdict to restrain employees from participating in an unprotected strike. An employer can also apply for an order of just and equitable compensation for the losses resulting from the strike. The labor court may not grant such an order unless 48 hours prior notice has been given to the respondent. Participating in an unprotected strike may constitute a fair reason for dismissal, but fair procedures must still be followed. Now let's take a look at the other forms of industrial action. Well, we have secondary or sympathy strikes. This is striking in support of the primary strike. The requirements are that the primary strike must be protected. You also need to give 7 days notice to the employer or 14 days if it's about operational requirements. The impact on the second employer shouldn't be more unreasonable than the impact on the first employer. But now let's talk about picketing. Well, this is public expression by employees of their grievances in order to make the grievances known to the general public. So workers who picket enjoy protection provided the picket takes place in a public place outside the employer's premises, unless the employer consents to it being on their premises. They also enjoy protection if they're members of a registered trade union, if the picket amounts to a peaceful demonstration, if the trade union has authorized the picket, and if the picket is in support of a protected strike or in opposition of a lockout. But now let's take a look at protest action. Well, this is to promote or defend the socio-economic interests of workers, so these employees shouldn't be engaged in essential or maintenance services. The protest action must be called or authorized by a registered trade union. And lastly, NEDLAC must be given notice, reasons, and nature of the action. But now let's take a look at lockouts. Well, this is the exclusion of employees from the workplace by the employer. And the purpose of lockouts is to compel employees to accept an offer or proposal with regard to a matter of mutual interest. And this is not a breach of contract by the employer. So we've got a defensive lockout and an offensive lockout. A defensive lockout is made in response to a strike or other action by employees or trade unions, and the employer should give 48 hours notice for this. An offensive lockout is made before a strike. But now let's take a quick look at dispute resolution amendments. Well, before we used to have pre-dismissal arbitration. But now that's become inquiry by arbitrator. And this process takes the place of a disciplinary hearing where an employer alleges misconduct or incapacity of the employee. The requirements for inquiry by arbitrator is that the allegations against the employee must concern misconduct or incapacity. The employee must consent. The employer initiates the process by filing the prescribed form and paying the prescribed fee. There's legal representation only by agreement, so the same inquiry as a normal arbitration, and the decision or ruling of the arbitrator has the same status as an arbitration award.